The Supreme Court is taking up two cases that could overturn major precedent on affirmative action. The practice has been a standard in higher education for 40 years to increase diversity on college campuses. But now a conservative and multiracial coalition of 22,000 students and parents argues it's actually leading to discrimination.
The cases challenge policies at Harvard University and the University of North Carolina, where race is among the criteria used in the admissions process.
Some applicants are incentivized to conceal their race. Others who were admitted on merit have their accomplishments diminished by assumptions that their race played a role in their admission. Racial classifications are wrong.
The university retains a powerful interest in preventing the backsliding that would occur if this court took away the power to decide this important social policy issue from the people of North Carolina.
The cases raise slightly different issues for the conservative-leaning court. Harvard's admissions policies are accused of discriminating against Asian Americans, while the case against UNC argues considering race violates civil rights law and the Constitution. The court is expected to rule next year. And joining us now for more on this is Brad Jacob, Associate Dean and Professor at Regent University School of Law. Brad, thank you so much for joining us tonight on Faith Nation. And I just first want to ask you, affirmative action has previously been upheld by the High Court, including in 2003, when it said it helps ensure racial diversity in higher education. Is there any reason to think this court might rule otherwise?
I think there are significant reasons, although you never know what the court's going to do until it does it. But some of the justices, notably Justice Clarence Thomas, have been very critical of affirmative action. The world has changed a lot in the last 50, 60 years. At one point, affirmative action was primarily directed at fixing prior discrimination. If a university had denied black students, say, then they might be giving them a leg up to try to even the scale. But today we're in a world where you're not typically correcting for discrimination, and so it becomes a question of, can a university use race as a factor just to get a desired level of diversity? And I'm not at all sure that a majority of the court will say that they can.
Brad, I want to ask you about the Supreme Court's own definition of diversity. Today in the hearing, Justice Thomas unloaded on the lawyer defending UNC's use of affirmative action in admissions, saying, quote, "Diversity seems to mean everything for everyone." The lawyer responded with the Supreme Court's own definition of diversity as a, quote, "broadly diverse set of criteria that extends to all different backgrounds and not solely limited to race." So would a ruling against UNC in this case mean rewriting the High Court's definition of diversity?
Well, I don't know that that definition is carved in stone. The court has spoken of it in different ways, in different cases. Most of higher education in this country is not very diverse on issues such as religion or political viewpoint. Most of the elite universities are very skewed towards sort of a secular and liberal perspective. So race is one factor, but race is the one where you have a real constitutional issue. And so I think the court may no longer be willing to accept the idea that the university can intentionally consider someone's skin color just to achieve that desired diversity.
And Brad, quickly, when do you think we'll have a ruling on this? By the summer, right?
Yeah, it'll certainly come down by the end of June. Often the big blockbuster cases, and this appears to be the big case of the current term, they often come down at the very end. So my guess would be not until late June, but they could surprise us and come down earlier in 2023.
Well, of course, we'll all be watching. Brad Jacob, thank you so much.
My pleasure.